Greetings. I hope you enjoy this narrated PowerPoint for Chapter 17, our textbook. In Chapter 17, we will cover real estate leases. Well, what exactly is a lease or a rental contract? This is a legal document between a landlord and a tenant. The lease gives the tenant the right of possession. A lease is also an encumbrance to clear title. That means that if the property is sold, the new owner must honor any pre-existing leases. A leasehold estate is a tenant's right to occupy land and or the buildings thereon. We need to define a few terms that are unique to Chapter 14. First, leasee. This is just a fancy word for the tenant in the rental agreement. The lessor is the owner of the property or the landlord. Remember that the tenant's interest, according to our previous slide, is the leasehold, whereas for the lessor, their interest is called a leased fee. Another term unique to Chapter 17 is reversion. This is the right of the owner to retake possession at the end of the lease period. And finally, tenancy. This is the period of a tenant's occupancy or possession of the property. There are 4 types of leasehold estates. The first is the periodic estate or the periodic tenancy. This is one that renews itself automatically for like periods of time. In other words, if one were to lease a room in a boarding house from month to month or perhaps from week to week, that would encompass a periodic estate. The estate for years has a specific starting and ending date. In other words, the lease starts on a specific date and it ends on a date. Doesn't necessarily have to be for years at a time, but it has to have a starting and ending date. For instance, if you lease an apartment, chances are you will sign a 6-month lease. This would be classified as an estate for years because it would have a starting and ending date, perhaps January 1st through June 30th of a particular calendar year. The next 2 types of leasehold estates are what's termed holdovers. And the word holdover means staying beyond the lease period. So first, we have the estate at will. The estate at will can be terminated any time by either party after the lease expires. In other words, this is a holdover with consent of the landlord. A tenancy at sufferance is also a holdover. However, this is when the tenant stays beyond the end of the lease without consent of the landlord. There are several elements that encompass a valid lease. First of all, both the lessor and the lessee have to be named in a valid lease. We also need a description of the premises. A legal description of the property is not required. Purely a street address will suffice. Third, there must be an agreement in this lease to convey possession from the landlord to the tenant, and the tenant accepts possession. There must be some language concerning the rent payment provisions. How much? When is it due? Of course, there is going to be a start date and some mention to the duration of that lease, and the parties must sign. We must have the signature of the parties to the lease. The Statute of Frauds says that leases greater than a year must be in writing. Less than a year, they should be in writing. We learned from Chapter 6 that leases can be recorded. They can be placed as a part of the public record, but they're usually not. Here are lease covenants. These are promises made by the landlord to the tenant. And the first one is quiet enjoyment. Here, the landlord promises the tenant that he or she has the right to use and enjoy the property without undue disturbance from others. Another promise or covenant made by the landlord to the tenant is the covenant of fitness. That means that the property is fit for use as intended. Therefore, if we are talking about an office building being leased by a tenant, it certainly should have all the amenities that go along with an office building, whether it is Class A, B, C, or D of office space. If it is a residential property, it should certainly have the amenities that go along with a residential property. It should have running water, it should have electricity, and certainly it should have heating and cooling. The last covenant is that of possession. That means that the tenant can hold possession against anyone, including the landlord. There are a couple of exceptions. One is that the landlord can enter to make repairs, and the landlord can also enter to show the property for sale. Of course, he should do that with notice to the tenant. In terms of landlord and tenant laws, for commercial properties, the courts usually are in charge of interpreting these lease agreements. For residential rental property, state legislatures often establish special landlord-tenant laws to strike a balance between what the responsibilities are of the landlords and what the tenants are responsible for. Some things these laws dictate include the amount of the security deposit a landlord can require, how many days' notice must be given a tenant before vacating a periodic tenancy, requirement for the landlord to deliver possession on the date agreed, the tenant's responsibility to keep his or her unit clean and undamaged, and the tenant's responsibility to obey house rules. And in terms of landlord-tenant law in Louisiana, the Attorney General of Louisiana has put together a very useful guide, and it's available to anyone online. Useful for both landlords and tenants alike. And you can download this booklet at this particular site. Here are some other terms that typically show up in leases. One might be an option clause. An option gives the tenant the right to purchase or continue to lease the property in the future at a specific price. Another term or terms that often show up are assignment and subletting. An assignment is a total transfer of the leasee's rights to another party. However, in this instance, the original tenant or the assignor remains liable unless they've been released. Whereas a subletting arrangement is where the lessee transfers only a portion of their rights to another. So here we're going to have a landlord, we're going to have a tenant, and a subtenant. Now, under a subletting, the tenant can transfer maybe a part of the premises or maybe a part of the term of the lease to a subtenant. Regardless, the tenant is ultimately responsible for the payment of that rent. A ground lease is a long-term lease of a site, only the site. In terms of length, we're talking about maybe 25 to 99 years in length. The tenant is responsible for erecting an improvement on that ground, on that site. But since the lease is for such a long period of time, the tenant will recover their investment in that improvement. So here we have some party owning the ground and another party that owns the improvement, that owns the building. A vertical lease is basically a lease of the air. If we can assign different parties different parts of the real estate, the surface, the subsurface, we can lease the area above the surface. That would be a vertical lease. And certainly in large cities like Chicago and New York, their public transportation systems own the ground, but they've been able to lease, they own the surface, and they've leased that portion above the surface so that buildings can be erected. Your book talks about the difference between contract rent and economic rent. Contract rent is the rent that the tenant actually pays, and it may include concessions. For instance, a concession might be if you sign a lease for, let's say, an entire year, you may get 1 month free. Once your rent is spread out over that entire year, your monthly rent is a little bit lower. So it takes into consideration concessions, what you actually pay based on that negotiation between the tenant and the landlord. Economic rent, or what's also termed market rent, is the rent the property would bring in an open market without concessions. Now, how can leases be terminated? Well, obviously, they end at the very end of the lease. They can be terminated due to mutual agreement where both parties agree to walk away. And then we have eviction. We have 3 different types of eviction. The first one is what you think about when someone's evicted. That's going to be sought by the landlord when the tenant violates some terms of the lease. Most likely the non-payment of rent, but it could also be due to the tenant breaking some agreement in the lease. They might be too noisy, they may bring in pets when they're not supposed to. That would be called an actual eviction. A constructive eviction occurs when the landlord does not keep the property fit for occupancy. In that case, the tenant cannot remain there due to the fact that the landlord has not lived up to their part of the agreement. That's a constructive eviction. A retaliatory eviction occurs when the landlord attempts to evict the tenant because the tenant may have complained that the property was not fit for occupancy, or maybe the landlord was doing something illegal and they were reported to various governmental authorities, and a retaliatory eviction took place where the landlord was retaliating against the tenant. This is certainly illegal. A lease can also be terminated due to eminent domain. Remember what eminent domain is. It's the right of a government or a quasi-governmental body to take private property for a public use. In that case, both the owner of the property and the tenant would be entitled to just compensation. And finally, a mortgage foreclosure. If the lease is subordinate to the mortgage on the property and the mortgage is foreclosed upon, then the lease terminates. Here's an example of a sample lease. All of the common clauses that we talked about are included in this lease, and it also includes all the elements of a valid lease. Now let's talk about the different methods for setting rents. The first one is what's called a gross lease. This is where the tenant pays a fixed rent every month, and it is up to the landlord to pay for the expenses of the property, the insurance on the property taxes, etc. A graduated rent is a step up or a step down in rental payments over the term. Often landlords will offer a graduated rent with a step up of rental payments over the term. This would be ideal for a newer property and to entice tenants to sign a lease, a long-term lease, and then they would increase the payments over time by a certain amount or by a certain percentage. A step-down lease would be ideal for an older property that just isn't as doesn't offer the same amenities. It's not as sexy as a new property. So to entice tenants to sign a long-term lease on an older property, the landlord may offer a step-down lease where the rental payments start out at a certain level, but then they decrease over time by either a certain percentage or by a certain amount. A net lease is where that's rent plus expenses, where the tenant pays a rental amount plus is responsible for the expenses of the property taxes, insurance, and maintenance. A percentage lease is when rent is a percentage of the tenant's gross income. This is ideal for retail properties. Chances are any of the stores you see in a mall or any retail establishment, those tenants are paying a rental fee plus a percentage of their monthly income. An index lease is when rent is tied to an economic indicator. For instance, in an inflationary period, with an index lease, rents will increase. So as that index goes up, like maybe the CPI, rents will increase. If there's deflation and the CPI goes down, rents would decrease in that instance. Leases that have an escalator or participation clause means that the landlord can increase rent because he or she has experienced an increase in expenses. We can also classify leases by length, but it all depends on the type of property. For commercial and industrial properties, long-term leases would be greater than 10 years. For residential rental property, a long-term lease would be considered long-term at greater than about 3 years. And we already talked about ground leases. Ground leases are for a very long period of time, between maybe 25 and 99 years. Let's talk about property management. The Institute of Real Estate Management, IREM, is the dominant professional organization in the property management field. It serves as an exchange medium for management ideas, and it recognizes specialists in the field, and it awards 2 designations. That is the Certified Property Manager. These are for members who successfully complete required educational courses in property management, and the Accredited Resident Manager. That's a designation awarded by IREM to members upon successful completion of an educational program for resident managers of apartment buildings. Another group is the Building Owners and Managers Institute. This is the second largest professional organization in the property management field, and they award a certain designation, the Real Property Administrator, only after their members have completed all 7 of their courses. When it comes to property management, there are various things that a manager has to consider. First of all, advertising. How are you going to attract tenants to your property? Second of all, tenant selection. Certainly, all landlords, all property managers want to have good tenants, those that pay their rent on time and treat the property as if it's their own. Managers also are responsible for helping to set security deposits and collecting them and determining whether or not they have to be awarded to tenants once they move out, or are they kept by the landlord. Tenant retention, certainly, again, all property managers want tenants that pay rent, follow rules, treat the property as if it's their own, and stay a long time. Managers are responsible for collecting rents, and we also need to consider whether a property will have an on-site management team or an off-site team. On-site management is a term that refers to property management duties that are performed on the premises, usually called a resident manager or a superintendent. A resident manager and management company are fiduciaries of the owner. The general rule of thumb when it comes to residential rental property is that an apartment management that has an on-site manager can handle about 50 to 60 units alone. Landlords might also consider an off-site management team. That's a term that refers to duties that can be accomplished without being on the premises. Here are some key terms from this chapter. and hopefully you'll have some familiarity with these terms after listening to this PowerPoint.